Thank you, Chair Hawley, Ranking Member Durbin, and members of the subcommittee. Thank you for inviting me to testify today. My name is Lee Hepner. I am Senior Legal Counsel at the American Economic Liberties Project. Over the past several years, I have studied and written about emerging technology platforms and the rise of surveillance pricing. As my colleagues have stated, surveillance pricing is the targeting of different prices at individual consumers or granular consumer segments based on their private, personal information. Everything from your precise location to your social and professional networks, your shopping history, your marital status, inferences about your physical health and financial status, your online browsing habits, even the way your cursor moves on your computer screen. These technologies are designed to estimate the highest price any given consumer is willing to pay at any given time. They also serve to erode any notion of a fair and predictable price. The Price is Right, the longest-running game show in American history, was based on this idea that a common price was one thing that buyers and sellers should all know about a market. We have built our society based on the same idea that prices for the same goods and services should be relatively equal to all comers. The compilation of dossiers of data on every single person in America and their use to organize surveillance pricing represents a break from this fundamental conception of fairness. Now, fairness is a term that is pervasive in our laws, many more than a century old, that govern prices to ensure they are transparent, predictable, and competitive. We have passed laws to make sure that one party cannot exploit its power or superior access to information to discriminate against weaker market participants. However, there is now a lack of clarity in laws that evolved during a period of history when individualized price discrimination was thought impossible. Companies have interpreted that lack of clarity as a green light to entrench surveillance pricing. In my written testimony, I survey how antitrust law and general consumer protection statutes, particularly at the state level, are beginning to address surveillance pricing. In antitrust cases against big tech firms, courts have acknowledged that superior access to data can itself be a competitive restraint, closing off markets to new competitors. In the consumer protection context, laws exist to prevent deceptive, fraudulent, or misleading practices. There is a robust body of law addressing quote-unquote fake discounts, which deceive consumers and induce purchasing based on false higher prices that no one actually pays. Surveillance pricing erodes that idea of a comparison price, or really any prevailing market price. Pending class action litigation against JetBlue and the Washington Post, brought by private citizens, is working its way through the courts in an attempt to limit surveillance pricing. In the Washington Post case, various subscribers paid wildly different prices: 50 cents per week, 99 cents per month, $20 per year. One subscriber saw their subscription price jump 300% in 1 year, all without explanation. The case alleges that those price differences were based in part on the personal data accessed across subscribers' Amazon profiles and across the internet. In a marketplace where every price is different, or where prices are subject to constant and continuous adjustment, there is a credible argument that every price is misleading or deceptive, because the concept of a standard price ceases to exist. Now, will any court accept this reasonable interpretation when the prevailing standard is that anything goes? I have my doubts, and it may take some time. We've seen cases against Target and Farmers Insurance settled before providing any further legal clarity. It may take years for other cases to resolve. Congress should not wait. It must act to update our laws in this new technological and legal regime. Congress should ban the use of personal data to price goods or services, with narrowly tailored exceptions. Several states and some cities have explored such legislation to protect consumers, to protect businesses, and to restore predictable and transparent pricing where surveillance pricing threatens to destroy it. Good legislation would not prohibit senior, student, or veterans discounts. It would allow loyalty programs, but ensure that any benefits are consistently offered to all participants in the loyalty program. A nation-leading model was rigorously vetted and passed the Colorado State Legislature before being vetoed earlier this year. In this Congress, the One Fair Price Act by Senator Gallego also gets it right. The polling and economic literature is very clear. Surveillance pricing is good for corporate profits and bad for consumers. But this is not just about cost. It is about morality and power. I'll close with a quote about airline pricing. Quote, Selective price gouging, non-cost justified discounts for big customers, and secret rebates seem to favor the large organized interests with competitive alternatives at the expense of the unorganized, uneducated, or captive passenger. These tactics are, quote, contrary to basic American precepts of justice. That quote is from the Heritage Foundation's Mandate for Leadership in 1980, the guidebook used by the Reagan administration. Surveillance pricing erodes that, quote, basic American precept of justice. We are happy to work with members of the Judiciary Committee to address this issue, and again, thank you for holding this hearing to discuss this critical issue. Thank you.
Thank you.